hate to age us both, but that was almost 40 years ago.
It was a long time.
It was a long time ago. This is an appeal from Judge Lewis Oliver out of Sumner County. He is a lawyer and a jurist that I have known for 40 years and who I have the utmost respect for and who I consider to be an exemplary lawyer and jurist. We, however, disagree with a number of his calculations in this divorce case. I know the court's had an opportunity to review the record and the briefs, and you will see that we've raised a number, and I forgot to add, may I reserve 3 minutes?
3 minutes, yes, sir.
I apologize for missing that.
3 minutes. Mm-hmm.
So please cut me down. The court determined and made a finding that you'll read that this is and was a complex case for the court, for the lawyers, for the parties, and for the experts. And the person that primarily made that difficult was Mr. Lee, who Judge Oliver found was not credible. Judge Oliver awarded the divorce based on overwhelming proof to Ms. Lee on the grounds of Mr. Lee's adultery and his inappropriate marital conduct, and found that Ms. Lee's testimony and credibility was bolstered, of course, by herself and through cross-examination and her witnesses. Throughout this lengthy final decree, you will see and read examples of the lies, the admitted perjuries, the non-credibility, the non-disclosures of financial information by Mr. Lee to his own expert, Vic Alexander, to the agreed-upon expert, Kurt Myers, who was hired by agreement between the parties to value these different businesses. It's a theme throughout the ruling that would take hours just to read of the credibility issues. The first issue that we raised was, and it might seem trivial to talk about a Lincoln Navigator vehicle, but I'm confused, my client's confused at the way the court found the debt and likewise how he applied the equity of the Navigator vehicle, because how this court determines whether there's error or not, it's a swing in the equalization goal that Judge Oliver was attempting to find in his decree. He pretty much was dividing things 50-50 as he saw them. Now, in the final decree, the court used a figure of $96,986 as the debt against the Lincoln Navigator. Well, we know from the proof presented at the final hearing, which occurred over 6 days in late 2021, through Trial Exhibit 79, which is the husband's asset and liability summary, that the actual debt was $74,322. However, when you look at the court's debt division later on in the final decree, you see that he has credited toward a debt payment to Mr. Lee that sum of $96,980 when it should have been $74,322. Now that's a difference of $22,664 that Mr. Lee does not have to pay in debt. And then when you look at the Lincoln Navigator, and it's the first time I've seen it handled this way, I'm accustomed to seeing the asset value, in this case the judge used a Kelley Blue Book of $50,000, less the lien owed to Lincoln Financial of the $74,322. The way I read that, or do the calculations, is it's negative $24,322 of loss. But if you look at the equity column, the court put $50,000 from its Blue Book value. And I don't know if he was thinking, well, I'm going to make Mr. Lee pay for it, but he did not make Mr. Lee pay for it as any kind of form of alimony. he made this a part of the division of property. But Miss Lee does not get an asset worth $50,000. She gets a vehicle that's upside down $24,322. So these figures affect either A, the expense, debt to Mr. Lee, he gets off with less, or B, the equalization payment is wrong because technically the Lincoln Navigator is not a $50,000 equity, does not have it. So we submit that we know from the husband's own exhibit that the court was in error on the debt, and we submit that the vehicle does not have a $50,000 value. She could not, because of the lien from Lincoln Financial, go out and sell it and make $50,000. So
Is it your position that if there was no lien on the car, the Navigator would have a value of $50,000?
That's correct.
Okay.
Through the
So the
judge.
question is, how did the court allocate the debt?
Right.
Okay.
And that's what I don't understand. I'm confused. I really am, because having been in this business 40 years of domestic relations practice, we typically see the lien resolved with the value of the asset. And then the courts can consider, if we're going to make the husband pay it, we'll do it with alimony or alimony and solido. He did not do that. So we assign error there. The second issue I wanted to raise today had to do with missing assets. The trial court was not asked after the hearing what it did with these assets, but in my review of the record, I was not the trial attorney for Ms. Lee. It appeared to me that missing from the court's final decree and the assets was two assets that Mr. Lee testified about, and from his trial exhibit 79. And the first one was a 401k under line 4 of trial exhibit 79 that was for $28,492. I couldn't find it in the listing, in the addition, the subtraction, etc. So if that's the truth, then the value of the marital estate is off by that amount, and therefore the equalization payment that Judge Oliver was attempting to make is off $14,200 to Miss Lee. That was line item 4. Then there was a line item 12 in Mr. Lee's exhibit, a Robinhood investment account that had $1,700. And I believe that testimony was, the number was corrected by the trial court on the exhibit because I saw a cross through it and then $1,700 written in there. I could not find that in the court's division of the assets, and therefore, even though it might not seem like a lot of money to a lot of people, but that's half of $1,700 is $850. That is, once again, missing from Miss Lee's side of the ledger. A third miscalculation or calculation issue that we raised, Your Honors, is the mortgage indebtedness against the house that was awarded in toto to Mrs. Lee. The court found that the debt was $499,000 of correction. That the mortgage had an indebtedness balance of $499,557 instead of its finding of $483,436. And what the wife and her trial counsel learned at the time following the hearing was that the husband, without disclosing to his lawyers, without disclosing to the court or to anyone really, had placed the party's mortgage in forbearance in September of the year of the divorce. They went to trial in November that year. And no one knew about it until right after the hearing and while the court, Judge Oliver, was preparing his final decree. And to their credit, counsel for the wife immediately filed motions for the court to take a look at this, correct it, and as I'm reading through the transcript, I clearly see that he's interested in knowing why Mr. Lee did not disclose that he had done that with the mortgage, thereby increasing it, the mortgage balance, and causing Judge Oliver's numbers to be off. But Judge Oliver never did anything else about it or made mention of it in the record, other than to say that if I've messed up on any of these numbers, the Court of Appeals will straighten me out. So he just kind of let it go. And the problem is once again, in awarding the house to my client, Ms. Lee, she's got more debt against it than the trial court thought. And therefore, the equalization payment is therefore in error by, it looks like, almost $17,000, and half of that.
So was Ms. Lee obligated on this mortgage debt as well?
Yes.
So how did Mr. Lee execute a forbearance without her involvement?
We don't know. We didn't know about it. And the trial court has noted his non-disclosures of financial information, of his uncooperation with the experts, so many credibility problems. I understand the problem that Judge Oliver had in trying to figure these issues out.
How was the 401k that was omitted brought to the trial court's attention?
It was not. It was not. I discovered that in reviewing Ms. Lee's appeal, that it was missing.
So you're almost out of time, and I want to make sure that we talk about the cross appeal issue here, which is Uber.
Correct. I was saving that for my 3 minutes. Or
Well, let's get into it a little bit now, because I want to ask a few questions with respect to that. So there was a court-appointed expert, shared expert initially, who testified about evaluation.
Mr. Myers.
Right. And then Mr. Lee hired his own expert to offer, but they both testified about valuation of that. Wasn't the company, but actually his ownership interest in that. Is that correct?
The 33.71%.
Right.
Well, Mr. Alexander did not perform a valuation of the business. He was hired by Mr. Lee to critique Mr. Myers' valuations after he made them.
Okay, so when I look in the decree and see the court's analysis on the valuation here, he is not weighing then a separate valuation offered by Mr. Alexander. Just Mr. Alexander's concern that the debt was not properly considered in the context of the valuation.
Right. And of course, you read about the money, that Mr. Myers testified that the best indicators for the value were the actual transactions from the company's equity. And they had raised $2.15 million to investors.
But the notes in question were convertible, were they not?
Convertible notes.
Okay.
But they don't say that the note holder is entitled to payment plus to receive equity from it.
Okay.
And along that line in Trial Exhibit 79, you will note that Mr. Lee testified that the equity value of Uber was $24,000. They take the position on appeal that it's zero. And he also put on his exhibit, Vic Alexander, $24,000, but Mr. Alexander did not perform a valuation of the business.
But Mr. Meyer did.
Mr. Myers.
All right, thank you. We'll hear from you further on rebuttal. Mr. Caparella? Good afternoon.
Good afternoon, Your Honors. Donald Caparella, the National Bar, representing Jeremy Lee. I'll begin where we ended, the cross appeal. Cross appeal involving the value of an asset normally involves a question of fact and to some degree an abuse of discretion standard as to whether or not the valuation is done properly. And valuations often involve a situation where one side says the valuation is this, another side says the evaluation is this, and the trial court picks something in the middle, and that's almost never reversible on appeal. That is not the situation we have here. We have a startup company that began in September of 2020, the UDH company, had no income in 2020, undisputed, lost $710,000 through the next year, and was valued in its 11th month at the trial, in August of 2021. The only real proof about its value related to the 17 promissory notes, which were identical, and they added up to $2.15 million. The only testimony of value was by Mr. Myers, who started out as their joint expert, ended up mostly being wife's expert. He says that the cap price of $17.5 million was the value, but the trial court rejected that, said, no, that can't be right. And nobody has raised an issue about whether the trial court got that part wrong. But the trial court then went to a secondary value that he gave, the adjusted book value, which he said was $2.13 million. But this is why we don't have a situation where he's picking a number between the range of evidence. This is a binary choice, because he testified absolutely that his opinion of $2.13 million for the adjusted book value of UDH was based on his assumption that the promissory notes did not have to be paid back. That is a legal question that the trial court made no ruling about. However, we have paragraph 2, which is on page, quoted at length, quoted entirely on page 75 of my brief. Sorry, 72 of my brief. Hold on. And it says how you convert this debt to equity. And the promissory note is an appendix and it's in the record. Paragraph 2 says you convert the debt to equity on August 1st. But then it says, in addition, the holder shall be entitled to receive a payment which constitutes payment in full of this note, together with the accrued and unpaid interest hereon. Remember, this was a startup, so the only way to get investors to invest in this is to give them a surefire investment by giving them a promissory note with a security agreement on 100% of the assets of this company at 36% interest. So legally, these promissory notes must be repaid. And the only expert that testified about value for the wife said that I'm interpreting this as they don't have to be paid. But I think your honors can read this de novo and say they do have to be repaid. And why is that important? Because Mr. Myers testified that if I'm wrong about that, he specifically said, he's asked, the primary assumption you make for that asset method, which is what he did, is that the 17 promissory notes do not have to be repaid. Correct. He said that's correct. They don't have to be repaid. But then he was asked, because if they do have to be repaid, then the asset method, you admit, will be zero, at least maybe negative. And he said, that's right, it would be zero. So the only evidence in this record is if the promissory notes have to be repaid, UDH has zero value. If it has zero value, then you have an asset that the trial court found that it was worth $2.15 million. Husband's 1/3 interest was $531,000. You have an asset in a $2.7 million estate that is $531,000. That's 20% of the marital estate is worth zero. So you just dramatically reduced the size of the marital estate. And I've cited well-established law that says if the Court of Appeals makes a ruling that dramatically changes the size of the marital estate, you must remand and do a different property division.
So I looked at paragraph 2, the quoted passage, and I would describe this as an have your cake and eat it too provision.
Exactly.
So really, if you don't pay when due, you still get paid, but you also get membership interest. Is that the way it was supposed to work?
Well, you're putting in debt. It can be converted to equity. But even if it gets converted to equity, in addition, you will still get paid, and you aren't just stuck in a bankrupt company with all the other equity people. We know that because in paragraph 4, it says that we know that these, first of all, the records make it clear that this debt was never actually converted on August 1st like it says it was supposed to be. Because in order for it to be converted, in paragraph 4 of this promissory note, the note holders had to surrender the note to the company. So therefore they couldn't enforce it. So Mr. Alexander, in his rebuttal, testified that he agreed with Mr. Myers that if the notes had to be repaid, the value was zero.
Mr. Alexander testified.
He agreed when he did an analysis of Mr. Myers. He disagreed with a lot of his findings, but he agreed when Mr. Myers said that if I'm wrong about the fact that these don't have to be repaid, and they do have to be repaid, and Mr. Myers says they're worth zero, Mr. Alexander agreed there were zero. So all the trial court had was a legal decision to make, was do the notes have to be repaid? If the notes have to be repaid, then UDH is worth zero. There was no other proof. So there's no range of evidence to choose between. The opposing counsel in their brief tried to create what I would call a false equivalency. Husband agreed with his expert in an exhibit that in March of 2021 that he thought UDH was worth $24,000. But that was before the $710,000 had been officially lost by August of 2021. And the trial court, it's not even clear that the trial court even considered that number because the trial court valued UDH in August of 2021. Remember, this is a startup that lasted from September of 20 through the trial in August, 11 months. So the trial court valued it in August of 2021. Mr. Myers valued it in August of 2021. Mr. Alexander valued it in August of 2021. So the March number that husband said of $24,000 was never even in the picture. So it's not like the court picked a number between 531 and 0 and 24. 24 between 5 and 0. The question is it 0 or is it 531,000? It's 531,000 if the notes don't have to be repaid. It's 0 if they do. And there's no other proof in the record, so there's nothing to support the trial court's finding.
Do we know anything about the individual note holders here? I'm curious about what the relationship was to Mr. Lee.
The record doesn't really reflect that. All 17 notes, though, are in the record, and they all are in different amounts, but the notes are 100% identical. And I think you can say, when I agreed with your statement about this is a have your cake and eat it too type of an agreement, if the note holders have to sue to get their money back, the company has to pay the attorney's fees. There's provision after provision after provision in this promissory note saying that Mr. Lee and his company was desperate for some startup capital and were willing to do a very, very unfavorable promissory note to get that money in the door. 36% interest is one of the highest interest rates I've ever seen in a commercial project. So, but all you really need to worry about is, for this decision, is to determine whether you agree with our position that this promissory note was required to be repaid. If it was required to be repaid, then the value is 0.
Yeah, so I appreciate your argument about, well, really what we have is a question of law here. But I also am very uncomfortable taking a valuation decision outside the factual finding context. Let's say for the sake of argument that we don't agree with you, the evidence preponderates against the trial judge's finding the value of his ownership interest in this company. And we concern ourselves merely with the assets that appear to be overlooked or the debt that we misvalue. As I read your brief in part, it seems to suggest as well, yeah, the court might have missed that, but that's, there's really nothing an appellate court can do with that. Is that your argument?
Well, we're talking about 10 different issues, so it's sort of hard to conflate them all together.
I appreciate that.
8 or 9 of them are completely waived under the rules of appellate procedure, and I'll let my brief stand on why they're waived. But let's deal with the most sort of striking one. There were 2 retirement accounts totaling about $30,000 that apparently were left out, just not divided. Now, That was never raised in the trial court as to why that happened. So this is being raised for the first time on appeal. So we submit it's waived.
It's a Rule 36 type
Right.
issue.
But the problem with that is, if you say, even if you accept the fact that they were simply not divided, that just means they were left in Mr. Lee's possession. And they're 0.05, well, they're 0.5%. So less than 1/2 of 1%. If you are dividing an estate 50-50, and now the husband is at 50.05 versus 49.05, you don't tweak property divisions in the Court of Appeals. At least there's hundreds of cases that say that. And or you could just say it's de minimis. And that's true about all of them. Now, if you add all of their valuation questions together that are not the UDH question, all of them together, the $160,000 equalization judgment that they say should really be $244,000, they add up to $84,000. That's 3%. So that means husband got 53% and she got 47%. Again, you don't tweak that amount. You don't dive into this, because you'd have to give them everything they're asking for to get to the 3%. And a couple of them, they don't cite to the record. They don't cite to how you'd have to actually do all the work for them and find the stuff in the record to support the argument that the trial court even got it wrong. So now it's our position that on the UDH matter, you can leave all the trial court's division of marital property rulings alone for waiver issues, as well as the de minimis issue and all the other reasons, and just remand to have the court either value UDH as 0, or at least do the legal analysis that I'm asking your honors respectfully to do, read the promissory note, and see that it means what we say it means, which is that the debt has to be repaid. If you don't want to if you choose in your discretion not to make that ruling, you can send it back to the trial court and have the trial court determine whether or not these notes have to be repaid. The trial court just simply made no ruling on what I submit as a purely legal issue. And since the evidence the evidence preponderates against a trial court's ruling if it's undisputed that the value is 0 based on what the promissory note meant.
Yeah, if we pull that string, I don't feel like you could. That's as big a problem as tinkering with the property division. In my view, it seems like to me that we would have to go back and let the court look at everything, including the omitted items, and then also would they also have to look at alimony decision again, because a component of the alimony decision is the property division. And now we have said, well, wait a minute, your property division was all wrong.
Well, I've seen many times when a trial court's property division is changed in one large way, instead of the court doing the more careful analysis about these 10 issues they've raised, you could send the whole thing back based on this really big problem that is a purely legal issue that the trial court made no ruling about, and these little issues. The problem with that, while you could do that, I think the rules of appellate procedure need to mean something, and they've waived almost all those issues. So it would be simpler if we went back with the issues that haven't been waived and only that UDH problem. And a $531,000 mistake in a property division, meaning the husband has a company that is worth nothing and yet is credited with $531,000, is exactly the kind of issue that this court should look carefully at, and particularly since the underlying issue is a legal question, you're not having to reconsider what the trial court did. You can do something the trial court failed to do and look at it de novo. Well, lastly, as far as the issues of, we have a claim for attorney's fees on appeal. I'll rest on my brief on that as far as the other problems with the failure to follow the rules of appellate procedure, the 60,000 word brief and all that sort of stuff. I'll rest on that. Now, we also have a claim for attorney's fees on appeal, though, because they appealed an alimony ruling, and 365103C says when you appeal an alimony ruling and you lose, this court has the discretion to award reasonable attorney's fees on that as well. So we would like you to consider reasonable appellate attorney's fees on that. So in conclusion, I would respectfully say that the trial court should be reversed on the UDH ruling and find waiver on the things that they waived before this court and send the property division back. And we are not specifically asking that the alimony ruling be reversed. However, sometimes courts do, when they reverse property division, reverse that as well, but we are not specifically asking the court to reverse the alimony ruling. Thank you, Your Honor.
Thank you, Mr. Caparella. Mr. Jackson,
Thank you again.
what do you say to the waiver issue?
As to which issue?
Well, he says about 8 of your issues are waived, partly because they weren't raised in the trial court and other grounds.
The issue with the 2 accounts not listed that I raised in this appeal were a part of the final hearing. They are on Trial Exhibit 79. So we're claiming the trial court erred in not listing in its equalization. This court did an equalization, did not do an equitable, it did equalization. So these assets were not listed, and that's a lot of money to Mrs.
So
Lee.
the court, you're saying the court was presented evidence of the 401K. I don't think the court was presented evidence of the smaller Robin Hood account. Am I right about that?
Mr. Lee took the witness stand. He was cross-examined. In his direct, he presented Trial Exhibit 79. Trial Exhibit 79 has his line items of accounts. In that trial exhibit are those 2, for example, accounts that I raised on appeal that the court erred in not listing in his final decree. So I believe, if I answer Judge Clement's question, we have not waived those. Those are a part of the final decree, except they weren't listed, but they were a part of the proof. And, you know, $500,000 might not be a lot of money to Mr. Lee, but if it's $65,000 that we're seeking for Mr. Lee, that is a lot of money. That percentage, whatever it is, these things add up. And the basis of Judge Oliver's whole opinion was equalization. So if he's off on debt, that hasn't been denied. If he's off on values, if assets presented as evidence are missing, this whole ruling.
And so what about my concern is that when you pull the string on a property division and determine it has to go back to look at these items, and I mean, we can assume maybe the court was going to do 50-50, but I don't know that for sure. What about the question we have to look at alimony again and open that up as well?
Is that the alimony in solido judgment
I mean,
payment,
right,
or the?
because one of the factors to consider
Yes.
in alimony is the property division, of course,
Correct.
as you well know.
Yes.
And so if we're sending it back to look at property division again, I mean, doesn't
Yes.
that mean
Yes,
the alimony has to be considered again?
I agree with you, yes.
Okay.
Let me ask you, if there should be an adjustment of the 64,000 that you mentioned, what would be the percentages then for the wife versus the husband?
Well, I have argued in the brief the same theme that Judge Oliver has used, and that's equalization. So I've merely requested half of the net equity of the missing assets, a correction of the almost $27,000 of mistake on the debt.
And what would be the effect on the percentages again?
Well, one of the issues a court can look at in determining alimony is its allocation of the debt. So with respect to the navigator debt, it's twofold. You've got the trial court crediting Mr. Lee to pay more debt than he actually has to pay, but on his trial exhibit 79 is where we discovered at the trial, because he did not disclose it in discovery prior to the trial, that the navigator debt was not $79,000 or $96,000, it was $74,000. That's a huge swing on that. That's debt that he does not have to pay, that the court, whether the court considered in his alimony award or not. Then with respect to the equity question, the court has listed the Lincoln Navigator as a $50,000 asset to Miss Lee. it's not worth $50,000. It's upside down by $25,000+ because of Lincoln Financial's $74,000 lien, and the Kelly Blue Book value that Judge Oliver used was $50,000. So her equity, the equalization judgment, would be off.
All right, thank you, Mr.
Okay,
Jackson.
thank you, Your Honor.
And Mr. Caparella, for your arguments. We'll take your case under advisement.
Thank you, Judge.
Call the next case, please.